Hello students, my name is Ankush Sharma. We would be discussing the PYQs that have come in the mains examination of 2025. We will discuss the questions that have come for Polity and Constitution in GS paper 2. We're going to discuss this briefly. We're going to discuss the structure and the content that should have been written in the answer. If you take a look at the first question that has been asked, compare and contrast the president's power to pardon in India and the United States. Are there any limitations to it in both the countries? And what are preemptive pardons? 150 words. So if you take the question in context, it has three different parts. First, it is asking for comparison between India and US. The second thing it is asking for is limitations. And thirdly, what are preemptive pardons? Now, all of this you would have to write in 150 words. So before you start answering, you have to ensure that you structure it properly. That I'm going to write, let's say, 100 words here, then 25 here. Or the more appropriate thing would be that you write 70, 80 words for the first part and divide the remaining words for the next two, so that you're able to complete the answer within the appropriate time limit itself. If you take the first part of this, compare and contrast, what had happened is that this question was in current affairs. It was an expected question. What had happened is that in the United States, you had at that time President Biden, the former president, who had given preemptive pardons to his son and other individuals. In that context, there were multiple articles that appeared in the Hindu, the Indian Express. We covered it in the Forum magazine and otherwise also on the comparison between the pardoning power of the Indian president and that of the American president. In that context, the first thing that you would have to do is when you're writing the introduction is mention Article 72, which gives the power of the President of India to grant pardons. Within this context, mention that there is something known as clemency power. Now, clemency power includes multiple aspects. It includes the power to pardon, reprieve, respite, remit, or commute sentences. And within that context, mention what do we mean by pardon. So your introduction would consist therefore of two small paragraphs. The first paragraph is that there is something called clemency power and what are they. The second paragraph would define what is a pardon in relation to others. After this, you move on to the comparison part. What you have to make sure is that you divide every comparison into various aspects. You tell the examiner what are you comparing in this context. So let's say the type of power. That the Indian president does not have a discretionary power of pardon. It is only on the aid and advice of the Council of Ministers. While for the US president, it is a discretionary power. In India, there is no preemptive pardons, while it is included within the United States. What is the effect of pardon in both the countries? What is the jurisdiction? Meaning that the Indian president can apply pardon in relation to union laws. He can also pardon in relation to death sentences under state law and in relation to military courts, while the US president can only do in relation to federal laws and cannot pardon crimes under state law. While in India, there is judicial review over pardoning power, while in the United States, it can only be done on a very limited basis of obstruction of justice, which in itself is defined by the US Supreme Court. So these become the various aspects on how you should do the comparison and have it in a comparative format when you're structuring within the UPSC Mains examination. Then you get to the second part of the question, which is limitations on the power of pardon, divided into two parts because the limitations are not same in relation to India and the United States. The limitations on the powers of the president in India is that it is subject to judicial review. You have various cases that you're already aware of, the Madhu Ram case, the Kehar Singh case, among other. It is based on aid and advice of the Council of Ministers, cannot be given in relation to state law, and no provision for preemptive pardon. While within the United States, it has very limited judicial review, only on the basis of obstruction of justice, cannot be given in the case of impeachment. So let's say if Donald Trump has been impeached, then he cannot give himself pardon in relation to his own impeachment. Cannot be given in relation to state law, aspects that we've already talked about earlier. Then you get to the last part of the question, define what is preemptive pardon, meaning these type of pardons are given before the conviction or the trial has begun. It is recognized in the United States, but not in India. And the Supreme Court in various judgment has also made it clear and has clarified that pardon within India is only after conviction or the sentence has been given, not prior to it. Right? The idea is that when you talk about the pardoning power, so this is something you end up writing in the introduction, that this is meant to correct judicial error or meant to give ease in relation to when the sentence is quite harsh. Both of these can occur after the sentence has been given in India and not prior to it, right? So basically you understand on how to structure. You start with the introduction, mention what is clemency, then write what do we mean by pardoning power, draw a comparison in relation to various aspects between the pardoning power of the Indian president and the US president, have a separate paragraph where you define the limitations of pardon of Indian president and the US president, and then the last paragraph on what is preemptive pardon and the condition that is there in both the US and India. All right. I hope this answer is clear. Right. Then you move to the next question. The Attorney General of India plays a crucial role in guiding the legal framework of the Union government and ensuring sound governance through legal counsel. Discuss his responsibility, rights, and limitations in this regard. So what would happen is you start a basic introduction by mentioning who is the Attorney General of India, appointed by the president, highest law officer within India, just basic few facts that you end up writing in introduction. Then what is it asking are three different aspects in relation to the Attorney General. Responsibilities, rights of the Attorney General, and limitations on the powers of the Attorney General. So three different paragraphs that you might end up writing within UPSC Mains examination. If you want to do it in bullet points, you want to draw a mind map, that is up to you on how you want to showcase this type of information. Right? So the first aspect would be responsibilities of the Attorney General of India. Chief Legal Advisor, mention the article next to it, represents the Government of India in courts, and also has an advisory role under Article 143, whereby the presidential reference, whenever it is given, it is the Attorney General that represents the Union government in front of the Supreme Court. So this is something that is still ongoing within current affairs. So completely taken from Article 76 itself. Right. Then you also talk about the rights of the Attorney General of India. He has the right of audience in all courts across India. He has the ability to participate in the proceedings of the parliament and parliamentary committees. He can only participate in those parliamentary committees in which he has been made a member by either the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha and not others. The Attorney General does not have the right to vote in either the parliamentary committees or within the houses of the parliament, either Lok Sabha or Rajya Sabha, but he can participate in proceedings. He also enjoys the same privileges and immunities as a member of parliament. Right? However, there are certain limitations that are there on the rights of the Attorney General. And that what you can do is maybe when you're talking about the third aspect, which is limitations upon the AGI, that you can mention here itself. So there are various limitations that have been put on the Attorney General of India. The term of office is not fixed. So generally what happens is he is appointed by the president based on aid and advice of the Council of Ministers. Generally, when the Council of Ministers or the Prime Minister resigns, it is presumed that the Attorney General would also resign. It is a practice. It is not written in law somewhere that it has to be done. But generally, it is seen that the Attorney General would also give his resignation to the president if the Prime Minister or the Council of Ministers also resign. Further, his remuneration is also not fixed by the Constitution. He receives as whatever the president may determine. Apart from this, there are certain limitations that have been put on the AGI in relation to his private practice. The point is, the Attorney General of India is not a employee of the central government. He can still undertake his private practice, but in relation to his private practice, there are certain limitations that have been imposed on the AGI, and you can mention them separately. That he cannot take a case against the government of India. He should not defend people accused in criminal offenses without the permission of the central government. He cannot also advise any ministry, department of the government of India, statutory organization until he has gotten permission from the Department of Legal Affairs under the Ministry of Law and Justice. You mention all of these points separately, and what would happen is, what you have done is mention in introduction who is the AGI. Then you have made small paragraph on his responsibilities, on his rights, and on his limitations. And you have answered the question appropriately. Secondly, it is 150 words. So you have to structure accordingly. That if I'm going to write this much words in the introduction and this much words in all the 3 sections. So all of this has to be done prior. You cannot also exceed your word limit in the mains examination. Now, the Indian Constitution has conferred amending power on the ordinary legislative institutions with few procedural hurdles. Examine the procedure and substantive limitations on the amending power of the Parliament to change the Constitution. So what would happen in this question, 250 words? You start with the intro. In the intro, you mention Article 368. And what type of power Article 368 provides? It provides the Parliament with the constituent power. It is the only time in the Constitution that it is mentioned that the Parliament is undertaking the constituent power itself. Small introduction, you're explaining what Article 368. After this, you get to the primary aspect, whereby they have asked in relation to what are the procedural limitations and substantive limitations. And you make 2 paragraphs or 2 sections of the answer accordingly. So what are the procedural limitations? So there's a famous statement by Granville Austin. The person has argued that if you look at Article 368, Article 368 provides various ways, or the Constitution actually provides various ways to amend the Constitution. It is diverse, not complicated. That is the statement of Granville Austin, that the Constitution of India provides diverse ways to amend the Constitution. It is diverse, but not complicated. So if you look at what are the various ways in which you can amend the Constitution, you can amend through simple majority of the Parliament. So you have various provisions of the Constitution where it would be mentioned within the article itself that this article does not require amendment under Article 368. So what that implies is that this article therefore would be amended by simple majority. In that context, you have various provisions of the Constitution. You have second schedule, you have creation of new states, abolition and creation of legislative council or the upper house of state legislature, and various other provisions of the Constitution. And what would happen is you mention few as examples. Apart from this, you have 2 provisions which are given in relation to Article 368. Article 368 provides that there are certain sections which would be amended through special majority. So specifically for fundamental rights and DPSP, it's there. The other aspect, it ends up saying that wherever it does not require ratification by states and wherever it does not require simple majority, the presumption is every other section would require special majority itself. The last aspect would be for federal provisions, which require it to be passed by both the Parliament, by both the houses of Parliament by special majority. Then it also requires to be ratified by half the state legislatures. The state legislature need to ratify it through simple majority. Now, if you were to draw this in type of a Venn diagram, so what you can showcase is that constitutional amendment. Within this, you have 2 types. You have through simple majority through other provisions of the Constitution. The other aspect is Article 368. Article 368 in itself provides 2 types. One is by special majority and the other is by ratification by states. So overall 3 ways and 2 ways within Article 368 itself, and you mention it accordingly, and you also give examples in relation to this. So for federal features, you can give the example of GST Council, Article 368 itself, among other. Okay. The other aspect of procedural limitation that is also there, given in Article 368, that it has to be passed by both the houses of parliament, by both the Lok Sabha and Rajya Sabha, and there is no provision for joint sitting. Apart from this, the presidential assent also has to be given, like it has to be given assent by the president, but all of you are already aware of this, that it is a compulsion upon the president to give their assent to constitutional amendment bills. Right. So these are all the procedural limitations upon the powers of the parliament to amend. Apart from this, you have substantive limitations. First, obviously, being the doctrine of basic structure. You mentioned in relation to the Keshananda Bharti case. Apart from this, you also mentioned the Minerva Mills judgment. Minerva Mills judgment is important because it ends up saying that the power of the parliament under Article 368 is a limited power. And this limited power is also basic structure. So both of them end up providing substantive limitations on the power of the parliament to amend. You also give examples where it has been practiced. So in the Raj Narayan case, you had Article 329A. So Article 329A was added by, at that time, the government in relation to Indira Gandhi, which ended up saying that the election of the Prime Minister and the election of the Speaker of the Lok Sabha would be beyond judicial review. At that time, the Supreme Court in what is now the famous Raj Narayan case ended up calling those changes, or basically not having judicial review under Article 329A as null and void. Similarly, in the Minerva Mills judgment, the same thing was done, that the government made certain amendments to Article 368, which took away judicial review. In that context also, the Supreme Court ended up saying that judicial review is basic structure, declared those sections to be null and void. And most recently in the NJAC judgment, they ended up saying violates basic structure, specifically judicial independence and separation of power. And you give these cases as examples on how the substantive limitation has been put on the power of the parliament in terms of their amending of the constitution. Fine. So if you look at, therefore, the question, you mention Article 368, that it is a constituent power in the introduction. Then you mention what are the procedural limitations given in Article 368. Bicameralism, in the sense, has to be approved by both the houses of parliament, no joint sitting, presidential assent. Then you get to another paragraph on substantive limitation, mention doctrine and basic structure, basic background, Keshananda Bharti case, mention what was said in Minerva Mills judgment also, and lastly, give examples in relation to Raj Narayan case, the NJAC judgment. The only reason I mentioned these two are not Minerva, because you've already mentioned prior to this. All right. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. In view of the above observation by Supreme Court, explain the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability in India. 250 words. Now, if you see this particular statement, constitutional morality fulcrum which acts as an essential check upon the high functioning citizens alike. So this line in itself on constitutional morality, you need to mention this in the constitution, that it has been taken from the NCT of Delhi case. So it was a particular line that was said by the Supreme Court in the NCT of Delhi on National Capital Territory of Delhi case 2018. So it needs to be mentioned here. Within this, then you also mention various other aspects in relation to constitutional morality. One of the famous quotes of Dr. Ambedkar, you can mention here, that constitutional morality is not a natural sentiment. It is not a natural sentiment. It has to be cultivated. It has to be cultivated. So basic line on constitutional morality, and you mention to the examiner where this statement has also been taken. Within this judgment itself, you have the Supreme Court, which has ended up saying various aspects. It ends up saying that constitutional morality acts as a check and balance, acts as a check and balance. Check and balance on what? On abuse of power and prevents tyranny, right? It ensures that there is no abuse of power either by the legislature or by the executive. It ensures and prevents that there is no tyranny by either of the two organs of the government, the executive and the legislature. Within this, there's a famous statement that was said by the Supreme Court in the Manoj Narula case, which was then again mentioned in the Government of NCT of Delhi case. There's a line that on men and angels, that if we were governed by angels, then you would not require check and balances. And if men were angels themselves, then also you would not require check and balances, because again, men would be governing as angels. But none of these aspects are there. Neither we're being governed by angels, neither men are angels. And therefore, what you require are means to ensure check and balances so you can prevent tyranny of the executive or even the legislature. How do you prevent this? You prevent this through constitutional morality. What I've just said in relation to the Manoj Narula case, I'm paraphrasing, but it's a small line that you can sometimes write in the conclusion or the introduction itself. Apart from this, the Supreme Court has also said that it ensures good governance. So you have a very small paragraph in which you have explained what is constitutional morality. You've explained that this particular statement has been taken from this case. You also explained what Dr. Ambedkar has said, that it is not a natural sentiment, it has to be cultivated. Then you also mention why it is required, that it acts as a check and balance on the abuse of power and prevents tyranny of the executive and judiciary. It also, the Supreme Court has also said that it provides for good governance. It establishes constitutional trust. Right? It establishes constitutional trust. Same said in the Government of NCT case. Trust between the three organs and trust between the people and the government. When we talk about the idea of constitutional morality, what it basically means is that the morals on which the Supreme Court would interpret and decide on cases, on the morals on which the legislature should make laws, on the morals on how the executive should implement laws, those morals should come from the Constitution. And what are the morals mentioned in the Constitution? You can look to the preamble. It mentions justice, liberty, equality, fraternity. These are the morals on which the Constitution is based. So Supreme Court has on multiple occasions, you mentioned in the next paragraph that the Supreme Court on multiple occasions has said that the constitutional morality means morals that have been derived from the Constitution. Right. You give the example, the best example would be from the preamble itself, right? Where the preamble mentions the ideas of justice, equality, liberty, fraternity, and dignity of the individuals. You mention all of these as aspects. Within that context, then you have to get to the second part of the question. So first you mention one paragraph, what do we mean by constitutional morality? In this, you also end up giving citations of various Supreme Court judgments. You can give in relation to the Nas Foundation judgment. You can give Joseph Shine, Navtej Singh Johar case, right? So you can give the example where the Supreme Court has utilized constitutional morality in relation to various issues that were plaguing the Indian society in these Supreme Court judgments, Nas Foundation, Joseph Shine case, Navtej Singh, Jor case, and there are multiple other cases. So that becomes one part of the answer. The next thing you would have to do is the next part of the Constitution, where constitutional morality has to be linked to two parts. One is judicial independence, and the other is judicial accountability. Right? Judicial accountability. So in the first half, you have mentioned what is we mean by constitutional morality. Then in a small section, mention what do we mean by judicial independence and how do we ensure judicial independence within India. That the impeachment of judges is quite hard. We have a security of tenure for Supreme Court and High Court judges. We have a judge's inquiry bill in relation to impeachment itself. But the primary reason why this question has been asked in terms of judicial independence and judicial accountability is because of the Justice Verma case. Right? So in the Justice Verma case, you had this idea of in-house procedure, whereby you had the Supreme Court judges investigate other judges in relation to bribery, corruption, and other issues itself. It raised concerns whether the executive should be investigating judges or judges should be investigating judges. And the idea has been made that the reason why the executive has not been allowed to do that, or why the Supreme Court doesn't want the executive to do that through the CBI or the Delhi police or otherwise, is because then it can be used by these executive branches to allegedly blackmail judges, that it compromises judicial independence and it compromises with judicial separation of power in terms of executive and legislature. That was the primary view on the context in which the question is being asked. Do these ideas of constitutional morality, how do you imbibe them in relation to judicial independence and judicial accountability? So you have to make the argument that it prevents abuse of power. Prevents abuse of power. So that is one aspect of constitutional morality. So how can you prevent abuse of power in relation to the judiciary in terms of allowing judiciary to maintain its independence and still ensure judicial accountability? Right? So it goes back into the first half of the question, where you have written down various aspects of constitutional morality, that it acts as a check and balance, prevents tyranny, prevents abuse of power, ensures good governance, and various other aspects. And you now need to link it directly to concept of judicial independence and judicial accountability. So just define what both of them means and make the interlinkages as necessary in this answer. Also give reference to the Justice Verma issue, because it has been ongoing within the news in relation to the in-house procedure plus the impeachment procedure that might be carried out in the future. Right? So what you have done is link the static part also to the current affairs in your mains answer. All right, the next question, examine the evolving pattern of center-state financial relations in the context of planned development in India. How far have the recent reforms impacted fiscal federalism within India? Again, it's not a difficult question. Within your introduction, define what do we mean by fiscal federalism. In few lines, just mention what do we mean by fiscal federalism. You get to the second part of the question, or the first part of the question, evolving pattern, on how we have evolved in terms of ensuring center-state financial relation in relation to planned development. So one of the things that has been done in India is the removal of Planning Commission. You mentioned in relation to Niti Aayog, and more importantly, you mentioned that in India, now we have sector-specific development plan. Earlier, we used to have the 5-year plans that was done by the Planning Commission. Now we have sector-specific. So you can give various examples. Like we have sector-specific development plan in relation to manufacturing. So you can give the example of PLI. For semiconductors, for dairy, for horticulture, for telecom sector, in all of these aspects. So you can bring in various examples where you can end up writing. Like for the semiconductor, you can write down the semiconductor mission. Apart from this, one evolving pattern has been the introduction of the GST Council, and you mentioned that it is an aspect of cooperative federalism, where both the union and all the states together take consensus-based decisions on various taxation proposals. Right? So that becomes first part of the question. Then you talk about recent reforms and their impact. What you need to do is have a comprehensive answer rather than an elaborative answer. Rather than focusing on one or two topics in elaboration, ensure that you highlight all the multiple topics that have come up in which there has been a strain on fiscal federalism within India. So you start with the recommendations of the 15th Finance Commission, where there has been a decrease in state share, and the southern states have also raised certain concern with the population criteria, and that it benefits primarily UP, Bihar, and the northern states. You also talk about the recent discussion on the new terms of references for the next Finance Commission or the 16th Finance Commission, whereby the state share should be increased and the criteria for devolution should also be relooked at, inclusion, especially the population criteria. That tax devolution, whereby all the southern states plus Maharashtra, Gujarat in the past have raised concerns that for every rupee that they're giving in terms of taxes, they're getting very less back. While comparatively UP and Bihar, for every rupee that they are giving in taxes, they're getting much more in return. So you highlight that part. The other aspect is with centrally sponsored schemes. That a lot of the money that is coming from the union is not being devolved directly into the states, etc. Meaning that money is not being directly given to the state governments so that they can decide and spend accordingly. What is happening is a lot of the money, the central government is directly spending in the states through centrally sponsored scheme. It recently became an issue between the center and the government of Tamil Nadu in relation to the new education policy, where the accusation has been made that the union government has withheld certain funds because Tamil Nadu is refusing to implement the new education policy. Apart from this, highlight the concerns of increasing debt levels of the state and rising fiscal deficit. Give the examples of Kerala and Punjab. Also highlight the recent RBI report, whereby RBI has ended up saying that the same issue that has happened with Sri Lanka in how they have gone into a debt crisis around 2023, the same issue can occur within several states within India. Division to local governance, whereby you had the 15th Finance Commission ended up saying that the money that they allocate to local governance has not been actually properly allocated by the states to the panchayat and municipalities. One of the primary reasons is that the states are not willing to form state finance commission. So highlight that as a issue. Cess and surcharge, whereby the union government has increased its own revenue by imposing cess and surcharges. But this money that the union government is earning from cess and surcharge, it is not part of the divisible pool. So this money is not going to the states. Loss of revenue post GST for states and how they're coping with this, and the rising financial burden for states, whereby it has been said that in 2014-15, the total state government expenditure was about 52% on priority sectors like education, healthcare, welfare schemes, which has now increased to 63%. So what you end up doing is highlighting various points comprehensively rather than elaboratively, that these are the various concerns that have come up recently in relation to fiscal federalism, but also have a good conclusion, right? A generalized conclusion that India should move towards and focus upon cooperative federalism and competitive federalism. The next question, discuss the evolution of the collegium system in India, critically examine the advantages and disadvantages of the system of appointment of judges of the Supreme Court of India and that of the United States. 250 words. You start with what is the collegium system and its evolution. Start with mentioning Article 124, that every judge of the Supreme Court appointed by the President in consultation with the Chief Justice. Then mention the first judge's case where the Supreme Court ended up saying that president is the final authority and consultation does not mean concurrence. While in the second judge's case, you had the Supreme Court say that consultation does mean concurrence with the opinion of the Chief Justice of India. While the Chief Justice of India would also have to consult with two senior most judges of the Supreme Court. So for president, consultation now means concurrence, but for the CJI, he only has to consult the two senior most judges. These three together, CJI plus the two senior most judges, came to be known as the collegium itself. By the time you get to the third judge's case, it ended up saying that Chief Justice of India would have to consult his four senior most judges. And this would now is the current system of collegium within India. And if any of the two judges do not agree with the recommendation of the name, then it is advised to the Chief Justice not to send that name forward. If the Chief Justice does send that name forward to the President, then it is not an obligation upon the President to accept that name. Apart from this, then finally mention the fourth judge's case, whereby the government or the Parliament enacted the National Judicial Appointments Commission, was declared null and void by the Supreme Court for violation of basic structure. Which part of basic structure did it violate? Independence of the judiciary and separation of power between the judiciary and the legislature and executive. Also add one more point, whereby both in the second and the third judge's case, so it was said in the second judge's case, reaffirmed in the third judge's case, that the senior most judge would become the Chief Justice of India. So what you have told is a basic evolution of the collegium system. Then you have to compare in relation to India and the United States. First mention how judges are appointed in the United States. So federal judges are appointed by the president and they're confirmed by the US Senate. So they're nominated by the US president. They go to the US Senate, which is their upper house, where they are confirmed. So you have the involvement both of the executive and the legislature in the appointment of judges. Now, you highlight various points on what are the various problems within India, within the US, in relation to appointment of judges. So what happens is that federal judges are appointed by the US president, and he ends up appointing people that are closer to his political views or to his political party. And this has been quite common within the US. It leads to the acquisition of a committed judiciary, whereby the judiciary is not committed to the people, but committed to the person in power. Right? They're not committed to the people, but committed to the person in power. And therefore, what you have are partisan judges. Judges that are partisan to the Republican Party or to the Democratic Party, the two primary political parties within the US. While judges in India are appointed through the collegium system. And what is generally seen is that they're non-partisan. Why? Because the role of the executive has been reduced massively by the collegium system itself. Then you also mention the problem within India is that because the executive or the US president is appointing judges to the Supreme Court, so he can take into context what is the representation of women in the US Supreme Court or in terms of other federal courts. What is the representation of the black community? What is the representation of other marginalized community there? And therefore, the president himself can take appropriate actions to ensure representation and to ensure affirmative action. While in India, that is not the case. One of the argument has been made is that there is a huge lack of diversity of women and reserved sections in representation as judges. Why? Because judges are appointed completely through the collegium system, and there is a certain opaqueness, lack of transparency in the appointments. Further, there has been accusation of nepotism and favoritism in the appointment of judges within India, where you don't write it in the mains examination as examples, but we are aware whereby nephews, son and daughters of former judges have been appointed as Supreme Court judges. And this is one of the primary problems of the collegium system in India. The same is not generally seen within the United States. In US, judges' appointment is actually discussed in the US Senate, so nominated by the president. A approved by the US Senate. But in India, there is a lack of transparency. It is not really clear what type of procedure the collegium is adopting to appoint judges within India. So within the past few years, they've come out with certain criteria that they're adopting, but there is a huge lack of transparency in still the appointment procedure. The collegium system in India is judicially innovated, while the US system basically follows what the US Constitution says. Right? So these are the various differences between India and the US. And what you have generally done is that this is an advantage in India, this is a disadvantage within India. And you have compared accordingly between both India and the US itself. Right? Discuss the nature of Jammu and Kashmir Legislative Assembly after Jammu Kashmir Reorganization Act. Briefly describe the powers and functions of the Assembly of the Union Territory of Jammu and Kashmir. Very straightforward question. First thing you have to do is compare the state of Jammu and Kashmir with the Union Territory of Jammu Kashmir. What are the various aspects you would compare on? Status, legislature, tenure, executive authority, power, residuary power, preservation, and the application of central laws. Like for example, initially, the state of Jammu Kashmir was a state under Schedule 1 with special provision under 370. Now it is a union territory under Schedule 1, and it has been bifurcated into two parts, Union Territory of Jammu Kashmir and the Union Territory of Ladakh. One had a tenure of 6 years, the other has a tenure of 5 years. If you look at in terms of central laws, within the state of Jammu Kashmir, because it had a special provision under Article 370, certain central laws were not implemented there. Now all the union laws are implemented there. One example you can give is of panchayats, because initially panchayats were not completely applied within the state of Jammu Kashmir, but is now being applied within Union Territory of Jammu and Kashmir. So these become various comparisons between both the state and the Union Territory of Jammu and Kashmir. Then you get to the second part of the question, powers and functions. Now, there is not much points to write in what are the various powers of the legislature, that is quite different from earlier, or the various functions of the legislature, that is quite different from earlier. So you combine all of them together and you make that the Legislative Assembly, or in this case of the Union Territory of Jammu and Kashmir, can make laws on all matters in the state list except for public order and police. The concurrent list is applicable to union territories, meaning what it basically means is that the Union Territory of Jammu and Kashmir, it has a legislative assembly. It can make any laws on the concurrent list as long as it does not come in conflict with the laws that have been made by the union itself. Any bill or amendment relating to financial obligations can only be introduced with the recommendation of the Lieutenant Governor, and the LG will have discretion in certain aspects that are outside the purview of the Legislative Assembly, such as All India Services or the Anti-Corruption Bureau. The other aspect you can also end up writing is the residuary powers, that in the state of Jammu Kashmir, it lied with the state government, but in the Union Territory, it requires parliamentary approval. Right? So these becomes the various powers and functions of the Union Territory, but because you've highlighted residuary powers over here, there's no need to repeat it in this context. And these are all the questions that have come in the polity section within GS paper 2. We have not gone into depths in relation to what we mean by Article 360 and all of that. The presumption is you've already done that in foundation. So we have discussed briefly as to how to answer these questions, how to structure these answers, and what would be the primary content that you end up writing here. I hope this has been helpful for you and for your own preparation in the UPSC Civil Services examination. And thank you for watching this video from my side and from ForumIAS. Take care. Hello students, today we're going to discuss the questions that have come for governance within GS paper 2 in the mains examination of 2025. Now, one of the first questions that has come is comment on the need of administrative tribunals as compared to the court system. Assess the impact of the recent tribunal reforms through rationalization of tribunals made in 2021. 150 words. Now, the first thing you would have to do in the introduction is look at the primary keyword, which it talks about administrative tribunals. You explain in brief what it means. So mention Article 323A that has allowed for the formation of tribunals, mention which constitutional amendment allows for this, and provide that the parliament can provide for administrative tribunals. What is the function of administrative tribunals? To resolve disputes and complaints in relation to recruitment and conditions of service of persons appointed to public services. Further, the Parliament can establish administrative tribunals for states or for two or more states. Further, the Parliament can also specify the jurisdiction of the administrative tribunals. So in brief, just mention what Article 323 mentions in relation to administrative tribunals. Then you get to the other part of the primary part of the question, where you need to compare the administrative tribunals to the court system, and specifically in relation to need. Why was there a need for administrative tribunals? One of the primary reasons was that there was higher pendency that was happening in the high courts, and later on that would be appealed to the Supreme Court. And to reduce the burden of the high courts or the existing court systems, administrative tribunals were created. Further, they were created on specific subjects, like for income tax that had existed much earlier, for subjects like for cinematographic and other aspects. So there can be some form of technical expertise which would be handling within these tribunals. There is also an aspect that all of the cases that would be related to that particular aspect can be completely shifted to the administrative tribunal. The primary aspect of the need for administrative tribunal was to ensure that it reduces the burden of the existing court systems. The primary advantage of the administrative tribunals is the next part that you would have to mention, where it allowed for speedy dispute resolutions. There was specific knowledge whereby there were both judicial members and technical members in administrative tribunals. It allowed for expertise to exist within the tribunal system. It was cost-effective, and it reduced the burden on the courts. The primary challenge that was there in relation to tribunal is one that was highlighted by the judiciary in multiple cases, is that there was a certain aspect of executive control over the tribunal. Executive control through the technical members. Apart from this, there was a sense of fragmented administration. Again, the divisions between the judicials and the technical expertise. And obviously, poor infrastructure. That is something that you find the district courts and to a certain extent within High Court also existing. Then you get to the next part of the question. Assess the impact of the recent tribunal reforms. Now, one of the things that had happened is long back the Supreme Court said that if a case is to be appealed of a tribunal, initially, it used to go directly to be appealed to the Supreme Court. Supreme Court later said that the appeal would lie, or the appellate jurisdiction would lie with the High Court. So what that basically meant is that initially the person would now have to go to the tribunal, which would be then appealed to the High Court, and which would then appeal to the Supreme Court. And in that situation, what it ended up doing was actually just delay justice, for delay verdict or the final verdict for that particular issue. Because earlier, you can take the judgment of the tribunal and directly appeal to the Supreme Court. But the Supreme Court later ended up saying, no, appeal first to the High Courts. And this really created a particular issue where the functioning of the tribunals became a problem. So in that situation, what the government ended up doing was reduce the number of tribunals within India. And all of the work in relation to certain tribunals was transferred to the
high courts. So one example that you can give in your exam is of film appellate tribunal itself, or you can give any example of any of the 7 tribunals that have been ended and their work transferred to the high courts. Further, it has been, again, we've talked about this, that one of the primary problem was in terms of appointment, in terms of the judicial and the technical members. Now, what the central government has done is that they have introduced certain rules in relation to appointments, tenure, and service condition of such members. They have also established a search selection committee for tribunals. One of the positive impacts of this is that it has streamlined the system of appointment. It has improved judicial consistency. Why? Because now the judgments would be given by the High Courts itself. So initially, when you had to go from the administrative tribunals to the High Court, that procedure has ended. Justice, well, is a little faster now, because now you can directly approach the Supreme Court in this. Further, it has enhanced administrative efficiency through mergers and ensured uniform rules in terms of appointment to tribunals in relation to all of these 19. The negative impact is that obviously it has increased the burden on the high courts. Further, the tenure is of 4 years, which has been criticized by the judiciary. There is reduced accessibility. One of the primary problems with the tribunals is where they are located. So many of them are just located either in Delhi or in Mumbai. So there is a certain level of reduced accessibility to tribunals. And one of the primary reasons why administrative tribunals were created was because of technical expertise that they brought in. Now, because you have ended such tribunals, there is a loss of technical expertise in certain specialized tribunals, like the copyright appellate tribunal. You can give as an example. You can give an example of any of the 7. That would not be a problem. So if you look at this question, you need to compare. You need to start with the introduction of Article 323A on administrative tribunals. You move on to comparing why there was a need for administrative tribunals in relation to the court system and what the government has done in relation to the Tribunals Reforms Act. And you also give the positive and the negative aspects to this. Why? Because they have asked assess. Assess would be you tell what has happened and you also give the pros and cons. And the last thing, if you have the word limit for it, is that you can give a way forward. Establish a centralized oversight committee. So Supreme Court in various judgments, including the Madras judgment, they have said to establish a National Tribunal Commission. Implement for uniform qualification and tenure extension, which has been said by the 272 Law Commission report. One generalized point, that promote digitization, which has happened in the High Courts and the Supreme Courts also. And you mentioned what was said in the L. Chandrakumar case, that tribunals are essential for efficient justice delivery. All right. The next question is, in contemporary development models, decision-making and problem-solving responsibilities are not located close to the source of information, and execution defeating the objectives of development. Critically evaluate 250 words. The basic idea of this is that who are we trying to develop? We're trying to develop in terms of the grassroots. But what is happening is that there is a certain level of centralization, that people sitting in capitals are deciding what should be done in the outer skirts or the outer parts of the country or outer parts of the state. So it creates a mismatch in terms of what is the expectation of the people, what is the requirement of the local population in terms of what is being decided at the center or in a centralized decision planning. That's the basic crux of the question. Within this, you start with a basic introduction. You talk about in relation to development. And one example, you can have multiple forms of introduction here, but one way that you can introduce is you can start by a quote, which is quite common for toppers to do within UPSC. So you can start with a quote of Mahatma Gandhi, where he ends up saying, recall the face of the poorest and the weakest man you have seen, and ask yourself, if this step is going to be of any use to them. Further, you highlight, there is a recent report by the Niti Aayog, and it has ended up saying that the Indian development model focuses on the lowest rungs of society, socioeconomic development, and income levels. It came out just, I think, last year by the Niti Aayog. Then you divide the question into two parts. What are the problems that happens when it is not located close? And what are the problems that happen when it is located close? So when the decision making is not located close, it leads to problems of information asymmetry. That meaning what happens at that with the local population, the correct information may not reach the center, or the complete information may not also reach the center. There is a delay in response. There is obviously a top-down approach, whereby the center is deciding what is going to happen in the other parts of the country. There is a one-size-fits-all policies that you're not taking into acknowledgement the local geography, the local needs, the local population, the local economy, and you're putting a particular development plan that may not be suitable for all of them. Further, there is a lack of accountability. Why? Because it's a top-down approach. There's a lack of homegrown innovation because, again, it is top-down. You're not asking the local population as to how are they dealing with the problems that might be there within their own communities or within their own particular area. So there is an ignorance of a down approach. There's a high cost due to red tapeism, there's the apathy of officials, and obviously all of this creates frustration among the people. However, you also have to highlight the other part of this, that what are the problems that happen when it is located close. So there is a lack of expertise. That if you allow only the grassroots to take care of the grassroots problems, they may not be able to receive the expertise that might be there with the center. Further, it also creates a particular problem where there are resource constraints also. There can also be elite capture by local strongmen, meaning, let's say if you've launched a particular scheme or you've given certain money for the local development, all of that can also be captured by the local strongmen, the local caste system, the local politics that end up existing within that region. It creates inequalities based on local governance. So you might have multiple districts that may undertake a different development plan, and what it would create is that some districts would have developed well, while some may not have. It also becomes difficult to implement national standards and objectives. So let's say if the government of India has launched Har Ghar Nal Yojana, or the government of India has launched several schemes that are meant to target the grassroots at the village level, what is going to happen is that if you only allow the local governance to take care of this, there would be different standards and there would be different outcomes that would end up happening. Some areas would develop much better as compared to others. It would also lead to short-term goals. What would happen is there would be elections every 5 years for panchayats and municipalities or otherwise. People would look to win for the next election. They were not going to plan for the next 15 or 50 years. It would also lead to greater freebies. This is one of the problems that we generally do see with local governance, that they refuse to tax and there is a lot of demand to give freebies and the implementation of freebies. Right? So you highlight both the aspects with multiple points. You don't need to elaborate on them, but highlight all it. These are largely the problems that would happen if decision-making is not located close, if decision-making is located close. Then you get to the way forward. What are the aspects that can be undertaken to ensure the development model takes the best of both of those? Best of what happens when the center is able to undertake decision-making in terms of, let's say, resources, national goals, and otherwise, and when the local governance is able to undertake, let's say, in terms of undertaking local solutions, local innovations. So you can highlight the Antyodaya empowerment, which is set by the Niti Aayog, that what we currently have is European style of welfare state, which is a lot of top-down approach. Antyodaya empowerment, as per the Niti Aayog, means that you acknowledge the local governance, the local population, and introduce them into some form of community development. Right? Further, what should be the development goal? It's a common theme of the Government of India: Sabka Saath, Sabka Vikas, Sabka Vishwas, Sabka Prayas. The Niti Aayog has also said that the Indian model for inclusive growth would include ensuring market economies, empowerment, and pragmatism, implement panchayats and municipalities and the roles that the constitution has provided them effectively. Such as one thing that you can end up highlighting is that both the panchayats and municipalities together have to form a district plan. So those plans can be effectively implemented. So what would happen is those plans would be made by the local governance, but implemented with the resources, the expertise, and other aspects from the state government. There is a need for financial devolution, introducing and improving localization efforts such as mother language, GIS, and socioeconomic assessment. You can also undertake community participation. You can give examples of Jan Sabha and through feedback loops. And lastly, undertaking digital inclusion through Jam Trinity and BharatNet and other aspects. Right? So if you look at this question, you first end up highlighting a basic introduction. What are the problems when the source of information and basically decision making is not located close, when it is located close, and you give a way forward, taking the best of the decision making by the center and decision making by the local governance. The next question, discuss the corrupt practices for the purpose of the Representation of People Act 1951. Assess whether the increase in the assets of the legislator or their associate disproportionate to the known sources of income would constitute undue influence and consequently a corrupt practice. 150 words. It's a very long question with the amount of words that they have allowed. So you end up, and you need to therefore reduce this in terms of how much words you can end up writing. So you need to make sure that the answer is comprehensive rather than way too elaborative. So you end up saying first, the Representation of People Acts defines corrupt practices under Section 123. If you don't remember Section 123, then only mention Representation of People's Act. There's no need to define or elaborate on this. Just highlight what are the various corrupt practices: bribery, undue influence, appeals on religion, use of national symbols to seek vote, publication of false statements, use of government machinery, and exceeding expenditure limit. Because of the word limit, you may not have the ability to elaborate upon them. So just highlight comprehensively that these are the corrupt practices that have been mentioned. What are the implications of these corrupt practices in the Representation of People's Act? That the elections can be declared void by the High Court. So you can give the example of the Raj Narayan case. Candidates may be disqualified up to 6 years based on the recommendation of the Election Commission of India. Further, there can be a form of criminal liability. A person can be given imprisonment or fine or both also. Right? Then you get to the second part of the question, which talks about disproportionate assets and corrupt practice. Now you need to say that it is not explicitly mentioned under the Representation of People's Act. So what the question is looking for you to argue is that yes, it is not mentioned under the Representation of People's Act. It is mentioned within the Prevention of Corruption Act. And within that context, you highlight various aspects in relation to the Prevention of Corruption Act. And the best way to do that is if you can bring in various case laws in relation to this. So what has happened is that in the PUCL case, the government has said that the citizens of India, have a right to know under Article 19, Clause 1, Clause A, which is the freedom of speech and expression. So that we have the right to know whether somebody has disproportionate assets, or basically assets that a candidate would have to file in terms of their election affidavit. Krishnamurthy case has also said non-disclosure of amount to undue influence. Lok Prahari cases, you would need to mention the legislature must disclose assets of themselves and their dependents, including increase during their tenure. There have been convictions on these bases, like the Punamudi and Rukumani case, where you can give the example. And further, you can mention the Abhiram case, where the Supreme Court has said that appeals to religion, caste, and community does constitute corrupt practice. And obviously, you all end a conclusion with a way forward in this particular aspect. So, the way forward would be in relation on how we can combat disproportionate assets and corrupt practices. So, independent auditing of affidavits by the Election Commission or Lokpal, real-time disclosure. What generally happens is when the election affidavit is filed, only then you generally find the assets being disclosed. But there should be a periodic disclosure of disproportionate assets. Strict penalties for concealment, including immediate disqualification, public funding, and fast-track courts in relation to electoral corruption practices. Because of the word limit, what you need to do is make sure your answer is comprehensive rather than way too much elaborative, because you have to explain every aspect of the question that has been asked. Okay. The next question, e-governance projects have a built-in bias towards technology and back-end integration rather than user-centric designs. Examine 150 words. The question is basically trying to say that one of the ideas of digital governance in India, the schemes that we have launched, particularly apps that we have launched, and the primary problem is that we're focusing too much on how to do data collection, get the numbers right, rather than on how the people feel when they're using those sites, when they're using those schemes. So what is happening is that it is a lot more government-centric rather than people-centric. You define e-governance as the integration and application of information communication technology in government processes. Why e-governance is required? To ensure efficiency, transparency, and that government processes become citizen-friendly. Within that, you first highlight the problem of bias. So you have various schemes like the Aadhaar card, the GST portal, and other aspects which largely focus on data collection or the back end. Right? Rather than focusing, so one of the examples you can give is of the GST portal. That initially when the GST portal was launched, it created issues for this, especially the small businessmen, in terms of a lot of technical glitches and otherwise. So you have to make sure that all of these e-governance schemes, apps and otherwise, they are a lot more user-friendly. Right? Further, there is a particular problem that we see with the Aadhaar card. This was recently said by the Supreme Court also in the Amar Jain case, that it is not inclusive of such laborers, asset attack victims, and otherwise. So recently in the right to digital access in the Amar Jain case was made a fundamental right under Article 21. Further, there is a one-size-fits-all. So one of the things that has been introduced is language integration, meaning if you want to take the benefit of a particular union scheme, you can do it in multiple languages, not just the scheduled languages, but what they're trying to also introduce is the idea that you can also undertake those benefits in terms of mother tongue. However, there is still a lack of consultation with stakeholders. So recently when Karnataka ended up launching the e-Khata scheme, they did not consult largely with the property dealers and otherwise, and how to make this a much more smoother process. Right? So you can give in relation to e-Khata scheme, which needed to also integrate the Patwari systems within that particular state. The metrics of achievement is largely how many people have we integrated? What is now the total number of Aadhaar cards? What is now the total number of people that are there using the particular app? So rather than focusing on quantitative terms, we should largely focus on qualitative terms. Like how many people are actually satisfied in using it? How many people end up becoming regular users of those apps? So let's say you have the eGov app. How many people are actually registered? That is one thing. But how many people are using the eGov app to actually raise grievances in relation to government processes? There is a weak feedback and grievance redressal, and lastly, it excludes marginalized sections and does lack last mile connectivity, meaning people that may not have digital access would obviously not be able to take benefit of such e-governance scheme. So digital divide also becomes a huge problem here. Then you get to, obviously, the way forward. So you talk about on how e-governance can be made more participatory and user-friendly. So first, bridge the digital divide, focus on qualitative measures such as active user, ease of access, inclusivity, including of persons with disabilities, how ensure that there are user audits, social audits, and grievance redressal mechanism. There is people interaction and not just interaction with the machines. Whereby if you have a particular grievance, it's not some AI or otherwise that is handling your grievances. There's an actual person to whom the people can talk to in relation to their grievances. You can also ensure that e-governance schemes and otherwise can also have BIS and CIS certification. And lastly, to have an all of government approach. What it basically means is, let's say you have various departments of the government. They work in silos. An all of government approach basically means is that there is integration, there is talks between all of them, whereby every department contributes and every department takes accountability of the functioning of the e-governance schemes. So this is a basic way forward that you would be able to write in relation to this question. All right. The next question is that the National Commission for Protection of Child Rights has to address the challenges faced by children in the digital era. Examine the existing policy and suggest measures the commissions can initiate to tackle the issue. 250 words. The first thing, mention what is National Commission for Protection of Child Rights. Right? Formed under the Protection of Child Rights Act of 2005, emphasize the principle of universality and inviolability of child rights. Basically, the constitutional rights, the statutory rights that are provided to children. It is the responsibility of this National Commission to ensure that those rights are upheld and protected. Within that context, what are the various challenges? So if you look at the question, they're asking specifically in relation to the digital era. So make sure that your question focuses specifically on this, does not move away from demand of the question. Right? So one of the problems is exposure to harmful and age-inappropriate content such as violent games, 18+ media, misinformation, and obviously hate speech. There is also an aspect of cyberbullying and peer pressure such as online harassment and cyber stalking, data exploitation and leakage without consent of the data of the children, sexual exploitation and trafficking risk, digital divide between the rich and the poor. There is a lack of psychological aid given to the students who may face cyber stalking, cyberbullying, and otherwise. There is also a lack of local solution. That a problem a child in Delhi and a problem child in, let's say, some rural part or some northeastern part or central India part may not be the same. So there is need to be a local solution to these kind of problems. Further, there is fragmented and overlapping legal protections that are provided to children. And lastly, identity theft, whereby fake profiles and other things can be created of children. So you highlight again in comprehensive terms rather than elaborated terms, what are the challenges or digital challenges that children may face. Then you get to the solutions. One of the aspects that you have seen in the West is the idea of safety by design, meaning that when you're creating a particular app, there are particular design mechanisms that already has to be pre-built in. So one of the things is, like in a lot of apps, there is always an age that is asked, and if you're a minor, then you have to get parental consent. One of the things you can give as a recommendation is that India can also follow the GDPR guidelines that the European Union has on minors. There's need to be a strengthening of grievance redressal mechanism, which should be done at the district level. So there is no one solution fits all. There is an aspect of local aspects being considered while protecting children. Further, you can link them to various schools and other coaching centers and otherwise for the protection of children. Promote digital literacy through community participation, strengthen existing law like POCSO, National Cyber Crime Reporting Portal, and otherwise. There can be school-based awareness campaigns, and largely the NCPCR the National Commission has released certain guidelines on edtech platforms. Those can also be improved and strengthened. So these are various way forwards, but you need to make sure that it is specific to digital era. Children may face problems in relation to, let's say, midday meal schemes, nutrition and otherwise, but that goes beyond the demand of the question. You need to make sure that it's much more concise in relation to the digital challenges and solutions. If you look at this question, civil society organizations are often perceived as being anti-state actors, then non-state actors. Do you agree? Justify. Now, within this context, first thing you have to do is define what is a civil society organization. There is a common definition that is generally used, which has been given by the UN Development Program or the UNDP, that civil society organizations are non-state entities that neither seek profit nor political power. They basically have a shared goal of promoting certain values. The next aspect that you talk about in relation to this is Article 19, Clause 1, Clause C, which provides the freedom of association. So the idea that you can have civil society organization or you can form civil society organizations in India comes from Article 19, Clause 1, Clause C, freedom of association. Then you highlight the various regulatory frameworks that are there for civil society organizations within the introduction, that they are regulated by the Societies Registration Act, India Trust Act, Companies Act, and also by the FCRA. This becomes a small introduction that you end up highlighting. You end up highlighting the definition, you end up highlighting what is the constitutional perspective in relation to civil society organization, that they have freedom of association, and the legislative aspect. Then you move on to the next part of the question, where the CSOs or civil society organizations are being perceived as anti-state actors and as non-state actors. So the reason why they have been perceived as anti-state actors, you highlight the various aspects. And it would be better that in the context of India, that you also give examples for majority of them. So foreign state influence. The first reason they're considered as anti-state actors is because they might be influenced by foreign governments that are hostile to India, like from Pakistan, from China, to a certain extent by the United States and others. One of the examples that you can give here is that there were protests in India in relation to POXO, in relation to Konakundalam, the nuclear power plant that we're trying to build in Tamil Nadu. During this time, the government ended up saying that there was foreign state influence in relation to such protests. So that is one example that you would be able to give here. Extremist and radical ideology. So you have certain organizations that have an idea of separatism, extremism, radicalism, that in India we have over time also banned. The example that you can give here is of PFI, the Popular Front of India. Vested interest like the Soros Foundation, whereby they have certain economical, certain commercial interest due to which they're trying to influence the policies and the internal politics of India. Certain civil society organizations obstruct. They obstruct the development of India in relation to economic and commercial interest. One of the primary examples that you can give here is of animal welfare organizations sometimes, where they do have certain, it may come from a good place, that their heart might be in the right place in certain situations, but it leads to problems within India whereby appropriate measures are not being able to take. They also become parallel power structures whereby they act as parallel to the government itself or the functioning of the government. This is sometimes seen with Maoist organization. And some civil society organizations function on identity and sectional interest, meaning what they end up trying to do is the old British philosophy of divide and rule, whereby they pick on a particular sectional or identity interest within India. It might be a form of advocacy. So in the form like you have Dalit organization, women organizations, which have a positive nature, as a part of non-state actors. But they can also try to do this so as to weaken India. Okay? So as to weaken India. Apart from this, what are the reactions or what are the appropriate steps that India takes in relation to such anti-state actors or civil society organizations that may have anti-state or may function as anti-state actors. So recently, the government of India cancelled about 6,000 FCRA licenses. You can give various examples. There is an example of CNI. This was a small organization whose FCRA was also cancelled. But there are about 6,000 that India has cancelled in the past few years. Certain organizations have been banned under UAPA, Unlawful Activities Prevention Act. So you can give the example of SIMI here. Apart from this, some organizations also get under the scrutiny of various investigative agencies, whether it might be the local police, but it can also be NIA, the National Investigation Agency, Narcotic Controls Bureau, and various other agencies. So one example that you can give here is that there is an international organization, Khalsa Aid, which is being investigated by NIA. So this is how you end up showing that various civil society organizations have been perceived as anti-state actors, and these are the reasons why they have been perceived. You are giving examples in relation to India and what has India done in retaliation to such organizations. Then you move to the next part, which is the idea of civil society organizations as non-state actors. So this is a much more positive aspect. This is a much more negative aspect. So first thing that you end up doing is give a small definition of what are non-state actors, meaning they have no relationship with either the government or any form of sovereign aspect to them, meaning they're not part of the state per se, or they're being funded by the state per se. Have a common definition that you can write here. Now, in this concept, they have positive contributions to nation and state building within India. One of the examples that you can give here is of MKSS, Mazdoor Kisan Shakti Sangathan. It was active in Rajasthan, and they were a primary organization that spearheaded one of the movements that led to the Right to Information Act within India. Apart from this, they deepened deliberative and substantive democracy within India. So you have several civil society organizations that have led to improving of deliberative and substantive democracy. So here you can give the example of the Anna Andolan, which, or you can call it the anti-corruption movement, under which we had the Lokpal and the Lok Ayukt Act. Right? You can also give the example of the Nirbhaya movement in this particular regard. Apart from this, there are various advocate groups where civil society organizations advocate for certain improvements in relation to societal or socioeconomic behavior or aspects. So multiple examples are there. So you can give the example of the Chipko movement, you can give the example of Narmada Bachao Andolan, you can give the example of Save Are Forest. There are multiple examples that you would be able to give here. You can give examples of women organizations, Dalit organizations that have led to improvement or have advocated for greater socioeconomic rights. One example that you can give here is of Kailash Satyarthi. Kailash Satyarthi had won the Nobel Peace Prize, and he had what is known as the Bachpan Bachao Andolan. So this is one example that you can give here, Bachpan Bachao Andolan. Certain organizations also work in terms of what is known as service delivery, that there is a particular aspect of state services where they end up helping either the state government, the local governance, the union government in trying to deliver a particular service that should have been done by the government itself. So one of the examples you can give here is of Akshay Patra. So Akshay Patra has been active in delivery of the midday meal schemes and other aspects. And some also act as watchdog of public interest. So one example you can give here is of Association of Democratic Reforms. So when you do polity, you sometimes often actually hear of Supreme Court cases, Association of Democratic Reforms case 2002, all of this, where they ensure that they protect public interests, more importantly, fundamental rights or legal rights of Indian citizens. Right. This becomes the context of your answer, whereby you first define what is a civil society organization. You give a definition, you link it to Article 19, Clause 1, Clause C, the regulatory framework that India has. Then you divide it into two parts, why they are perceived as being anti-state actors, and you give the proper examples for this, and what steps India has taken. And then the reasoning of CSO as non-state actors, again giving examples here. The question asks, do you agree and justify? The point is, you need to take a balanced answer to this. That you end up saying, yes, there are certain actions that civil society organizations can take that would make them or that approve or justify the perception of them being anti-state actors. However, the primary or the majority of the NGOs and others that are working within India do have a non-state actor status where they have been contributing positively within India. Right? Then you move on to the next question. What are environmental pressure groups? Discuss their role in raising awareness, influencing policies, and advocating for environmental protection in India. 250 words. Again, the same thing. You take the primary keyword, which is pressure groups, and more importantly, environmental pressure group. So you define what pressure groups are. It is an organization of people with shared interest and objective where they seek to influence public policy and decision making. One way that you make the difference between pressure groups and political parties is that pressure groups do not seek to capture political power. They only seek to influence those that are in power. Specifically, when you define environmental pressure group, is that they seek to influence public policy and decision making in relation to promoting environmental protection and conservation. Right? So, one small introduction where you end up defining both of these terms, pressure groups and environmental pressure groups. Now, if you look at the three aspects that they have asked, awareness, influencing policies, and advocation. So, it is difficult to differentiate as to what would be awareness and what would be influencing policy and advocacy, in the sense that when you talk about public campaigns are meant to influence policy, advocate certain issues, and they also increase awareness. So the best way would be is that you end up highlighting all of the points in relation to all the three aspects that have been asked within UPSC. Why? Because it is difficult to differentiate into three different categories. So you can then practice a lot of mind maps into this. You can write them in bullet points. You can make a circle with about 12 different points with their appropriate examples. So there are multiple ways in which you are able to showcase this type of answer within UPSC. So the first thing, public campaigns. So one of the examples that you can give here is of, let's say, various public campaigns that are in Delhi, Bangalore, Mumbai, and other places, like no littering campaign, or clean the city campaign, or clean the beach campaign, and all of these which you can end up highlighting. It is best that you separate protests, like say the RA Forest protest, with what are generally public campaigns. Like in Bangalore recently, there was a public campaign of cleaning up the sidewalks also. Further, there can be social media and social media outreach, educational programs that can be undertaken in schools, colleges, universities, and otherwise. There can be public reports that have come out from various agencies. So you can give the example of TERI or other organizations, private organizations including, that come out with these type of reports which seek awareness, influence policy, and advocate. You can give the example of public protests like the Safe RA Forest protest, the one you recently saw in Hyderabad University. You can give the older one like Chipko Andolan and various other examples. But it is best that you give examples from current affairs. Further, they lobby for legislative intervention, meaning making a law for the protection of cheetahs, making a law for the protection of tigers, making a law for the protection of Ganga dolphins, making a law for the protection of forests, various other aspects. So in that sense, making, you can give the example of WWF, which actually advocated for the Wildlife Protection Act long back. Right? Further, you have various agencies that partner up with private companies under corporate social responsibility. So one of the ways that companies spend money is they can also spend in relation to environmental protection. And you have various state actors, non-state actors that participate or work with companies in relation to this funding. One important example that you can give here is of judicial intervention in the form that a lot of people, advocate groups, end up filing PILs, public interest litigation, for environmental protection. The famous example that you can give here is of the MC Mehta case. MC Mehta case. Further, collaboration with state agencies through international agencies like UNEP. And lastly, when you get to the conclusion part, one thing that you can make the argument here is that these environmental pressure groups, what are they doing? They are trying to enforce the state duty that has been provided under Article 48A, which is TPSP, that it is the duty of the state for the protection of environment and wildlife. Similarly, they advocate for enforcing citizen duty under Article 51A G. 51A being fundamental duties, G talks about that it is a duty of the citizens for the protection of the environment and having compassion for creatures. In that context, this can become therefore your conclusion. That this, because this is a question that has been asked in GS paper 2, what you're doing is trying to link it back to polity also, right? Right? And within that context, I hope you have understood.
Now, let's discuss the question number 6, which is on gender issues. So question 6 reads, women's social capital complements in advancing empowerment and gender equity. Explain. Explain. Now, first of all, as introduction of this particular question is concerned, so in introduction, what we can do? We can simply define the keyword that has been given here in the question, and the keyword happens to be the social capital. Social capital. So when we talk about social capital, so simply I can write this particular thing that women's social capital, women's social capital refers to the networks, trust, solidarity, and relational wealth that they enjoy. Refers to their networks, refers to the solidarity with each other that they enjoy. Solidarity. Relational wealth refers to the relational wealth that they enjoy. Now, success of Lijjat Papad showcases that what if social capital is there, it can achieve. We have other examples also. For example, Ela Bhatt's Seva initiative. So the example of Ela Bhatt Seva showcases that when social capital between the women is there, when they trust each other, when they network with each other, when they have solidarity with each other, it can collectively bring the women out from the poverty, and same goes with the Lijjat Papad. Now, further we can add this particular thing, and formally how to put it, that also I will discuss. Then further we can add this particular thing. Social capital can complement the formal policy making, as well as it can complement the special schemes that government has brought. And social capital along with the legislative action can truly empower women, So these are the dimensions that I can explore in the introduction part. So I will summarize all these particular things in the formal sentence kind of formation so that you can understand. So I will define the social capital. I will say women's social capital can be defined as networks, solidarity, trust, and relational wealth that they share with each other. Such a social capital, the importance of social capital and value of social capital, or what social capital can achieve, can be seen with the success of Lijjat Papad enterprise as well as the success of Ela Bhatt's Seva initiative. Social capital, if utilized properly, can complement the legislative action as well as government schemes and can truly empower the women, So this is something that I can start with. Now moving on, I need now to write the point that how social capital will truly empower women, how empowerment and gender equity will emerge. So basically, social capital's role in advancing gender equity and empowerment. Number one, social capital builds institutional capital for women. Social capital builds institutional capital for women. When women share social capital with each other, social capital can build institutional capital. When women share social capital, they can form self-help groups, they can form Mahila Mandals, which enhances the bargaining capacity of women, and such enhancement of bargaining capacity of women leads to their economical, political and social empowerment. Then secondly, social capital can act as linking capital. Now, what do we mean by the linking capital? When the women have shared social capital, when they have networks, when they have relational wealth, by that network and relational wealth, they can connect with the state agencies. For example, they can connect with banks, they can connect with the other NGOs, and can better utilize the scheme. Then next point that comes in this particular direction is that social capital enables information sharing, which empowers women. Social capital enables information sharing. When women have trust with each other, when they have solidarity with each other, they share the information, critical information about income generating opportunities, information about government programs, legal awareness, which empower the women. After that, women's collectives, by social capital, women's collectives can be formed, and women's collective give more voice to the women in elections. They help them to effectively participate in the grassroots democracy. So social capital with the women enables women's collectives, which empower them politically, and enable them to carry effective participation in the Panchayati Raj institution. And fifthly, social capital within the women provide them a shared and safe social space where they can interact with each other, where they can receive the psychological and social support. So women, their concerns, their grievances, their insecurities, their anxieties can be shared with each other. That can only happen when the women have a trust on each other, when they have a network with each other. So social capital provides safe and shared social space to women, where they can share their anxieties, where they can share their vulnerability, and can seek the psychological and social support. Clear or not? So this is as how the social capital will empower. Now finally, the conclusion comes. So basically, we can say this particular thing: women's social capital transforms the scattered individual efforts of women in a whole and gives them more meaningful voice and enables more meaningful participation. So the scattered efforts of women, individual struggles of the women, they are consolidated, and a collective strength is given. So this is how we can address this particular question. Fine. Point is that please add the success stories such as Lijjat Papad. You can also add Kudumb Shri if you want, Seva initiative if you want. Okay, now we'll move to the next question. Okay, so the next question that we have here is question number 16, which reads: inequality in the ownership pattern of resources is one of the major causes of poverty. Discuss in the context of paradox of poverty. Now, first of all, introduction part. So basically, as introduction part is concerned, in introduction, what we can do? We can define paradox of poverty, because the entire discussion is to be made in the context of paradox of poverty. So that could be a good point to start with. So when we talk about paradox of poverty in introduction, I will define the paradox of poverty that it refers to a contradiction. Paradox of poverty refers to a contradiction where a country is blessed with abundant natural, physical, human resource, physical resource, human resource. But at the same time, country faces extreme levels of poverty and unacceptable levels of poverty. This is a paradox. So there are abundant resources, but at the same time, there is high poverty. So this refers to the situation of prosperity, poverty paradox. Now, we can connect this particular thing with the core demand of the question, that is inequality. Here I can say that inequality in the ownership of resources, is the primary explanation for this paradox, is the primary reason for this particular paradox. Primary explanation of such paradox. Clear or not? So I have given my introduction where I have addressed two things. I have explained the poverty paradox, and at the same time I have also given that inequality is the one which is driving this particular paradox of poverty. Fine. Also, you can add other ways also. For example, inequality in the ownership of resources is the driver. Now, it will be very good if we can substitute this with some kind of a data, that how this kind of a paradox or how this kind of inequality is existing in India. So basically, according to World Inequality Lab, 1% people in India hold 40% of wealth, which showcases the inequality that exists in India. Clear? Now, moving on in this particular direction, I will now move to the core demand of the question, where it shows inequality in the ownership is the major reason. So I will give different case studies. I will give different viewpoints that inequality is existing on multiple levels and it is perpetuating poverty. Inequality is existing and it is perpetuating poverty. So inequality perpetuates poverty. Okay. So in this direction, we have reasons. Reasons number one is land inequality. Now, if we see, historically, this was the problem. Even after the land reforms, this particular problem has not been solved. So majority of land is held by elite, and rich. Whereas now, majority of land is held by elite and rich, which is actually demographic minority, whereas a demographic majority is working as manual laborers. They are working as agricultural laborers, and because of that their productivity and marginal productivity is always less, and because of that they are always trapped in the vicious cycle. They are always trapped in the vicious cycle of poverty. Okay, then second that we have in this particular direction is capital and credit. So basically, when we talk about rich people, when they talk about the rich people have access to formal capital. They have access to formal capital through banks. They have access to formal capital through capital markets, which is available at low borrowing cost, whereas poor people always they are dependent on informal credit networks. They are dependent on money lender, which always charge very high servicing cost, which have charge very high debt. And because of that, because the capital and credit is in the favor of rich people, they get more and more rich. The next that we have is knowledge capital. So basically, when we talk about the knowledge, it has technology, for example, technology. It is largely held by rich and influential. Which drastically enhances the productivity and increases their earning capital. So this is why the inequality is increasing, and this inequality shifts more and more resource to the rich. So resource is there, but resource is not fairly distributed, which is driving this entire challenge. Now, what are the reasons for the emergence of this skewed structure? Reasons for the emergence of such or existence of such skewed structure. Now, reasons are like this. Now, why I am opening this more dimension of reasons? Because this is a 15 marker question, and therefore you have to also fulfill the length, that is 250 words. Reasons are this, that the tax policies are often the ones which favor the rich. There are weak labor protection laws. Laws that are there, because of which often poor people, they end up in doing more hard work and getting less remuneration for that. Okay, often what happens, corporates crunch small businesses, which provides the bread and butter to millions, lakhs and thousands, and sometimes millions of the family. Now, in order to solve this particular problem, there are some way forwards and recommendations that can be given. So basically, as we talk about the way forward, so in G20 2024, Brazilian president said that poverty is a scourge that shames humanity, and he proposed taxing the ultra rich. So basically, on ultra rich, on wealth, there needs to be special taxes and levies, as Brazil has proposed, which should be used for fair redistribution. Okay, then more focus on progressive taxation. Progressive taxation needs to be there. After that, in this particular direction, the next what we can suggest here, we can suggest the suggestions such as okay, robust social security nets. Robust social security nets are needed in this particular direction. Okay, after that, land reforms 2.0 are needed in this particular direction. Okay, redistributive policies, community rights over the resources needs to be recognized. Okay, all these particular suggestions can be given. Fine. So that is all about this particular question. And now we'll move to the next question.
Hello, students. Today we're going to discuss the questions that have come for international relations in the mains examination of 2025 in GS paper 2. The first question that has come is India-Africa Digital Partnership is achieving mutual respect, co-development, and long-term institutional partnerships. Within this context, if you see the question, it was there in current affairs. As we have seen in IR PYQs, that most of the questions that have come for international relations have some relevance within current affairs itself. So this idea of India-Africa Digital Partnership was also there in the Hindu newspaper, Time for New India-Africa Digital Compact, and covered for the UPSC students. What you had to write within this answer is first a basic introduction. Okay? A basic introduction on India and Africa, that both the countries are moving together forward in terms of digital partnership. And not just digital partnership, in terms of global South-South cooperation. Okay? Global South-South cooperation. And one of the ways that we're cooperating, digital partnership. Okay? Digital partnership. After this, you end up writing what are the various aspects of cooperation that both the countries have undertaken, right? So you highlight what are the various aspects. Within this, you end up writing one of the things that India is doing within Africa is that long back, this is during APJ Abdul Kalam's time, Pan-Africa E-Network, right? So you end up highlighting various schemes, initiatives that the government of India has undertaken there. We have also launched ONDC, UPI, BMAP, CoWIN, and various other digital initiatives that India has undertaken. Within this context, you can also write iTech, EROK. So EROK is for digital healthcare. You have eVidya for digital education. So all of these initiatives you end up writing. Apart from this, India is also giving certain levels of scholarships for African students to study within India. We undertake various scholarship under ICC SR, lines of credit that we have given to various African countries in relation to developing their digital infrastructure. Apart from these, there are various other points that you can highlight there. You also end up writing the various issues that have come up for India-Africa Digital Partnership. One of the primary issue is, well, it's an issue everywhere, which is China, is that we're not able to compete with the low cost and the Digital Belt Road Initiative that China has launched within Africa. This in itself is a problem or issue for India. The other is the investment coming from the United States and European Union. Apart from this, there are problems within the African continent itself. One of the aspects, digital divide, lack of infrastructure, political instability. So all of those also become problems that India faces within the African continent also. In relation to this, you can highlight a basic introduction whereby you end up saying that this digital partnership that we have between India and Africa is largely part of the global South-South cooperation. You highlight the various aspects in which India and Africa are cooperating together. Pan-Africa E-Network, ONDC, UPI, BHIM, CoWIN, iTech, EROK, eVidya, scholarships, line of credit. You can also talk about IIT being established within Zanzibar and various other initiatives that the Government of India has undertaken to build digital infrastructure within Africa. You also highlight the various issues. One problem being China, the investment coming from US and European Union. Apart from this, the problems that are there within the African continent itself. The digital divide, the lack of infrastructure. When you talk about lack of infrastructure, give the examples. So telecom towers, right? Telecom towers. Yeah. Optical fibers. So all of this India is also trying to bring to the African continent. At the end, you end up writing a basic conclusion. Yeah. So you end up writing a basic conclusion in which you highlight a generalized viewpoint, whereby, yes, we have mutual respect, co-development, and ongoing institutional partnerships. How do you concise all of this, what they have asked in the question, into a conclusion? You link it back to Indian foreign policy and our concept of Vasudhaiva Kutumbakam. Vasudhaiva Kutumbakam, that our foreign policy within Africa is guided by Vasudhaiva Kutumbakam. And there's one more aspect that you can also write, which is the Kampala principles. Kampala principles was given by our Prime Minister Modi when he visited Uganda, and he highlighted various principles which would end up guiding India's engagement with Africa. So this becomes a normal conclusion. These are good keywords that you can end up using within your UPSC answer. Right? So you get the basic idea of how to answer this question. Coming to the second question, with the waning of globalization, post-Cold War world is becoming a site of sovereign nationalism. Elucidate. 150 words, 10 marker question. There are multiple keywords that are used within this question. You have globalization, post-Cold War, and sovereign nationalism. You start the introduction by linking it to the demand of the question, where you end up highlighting a basic idea what do we mean by globalization, right? So what does it mean? Integration of the economy to the world economy. Integration of the economy to the world economy. How do you get this done? LPG. So you understand liberalization, privatization, and globalization. A basic definition of globalization. Then you end up highlighting the next part, that what it is really talking about is the post-1991 period, right? Post-1991 period. So with the breakup of the Soviet Union, we had entered into the era of the post-Cold War. Initially, it was reflected by US unilateralism, whereby US was a sole superpower. And after 2008, you had a movement towards multipolarity. But you don't need to go into that much depth. You only mention that the era that we're going to talk about is the post-1991 era, or after the Cold War. But you have to make sure that you talk about current affairs. Right? It doesn't mean that you start from 90s and talk about the 2000s and then you come. No. You don't need to give 30 years of history here. You need to link it back to current affairs in this. So what do we mean by sovereign nationalism? It is the idea of unilateralism. Okay? It is the idea that countries are undertaking unilateral decisions. And you need to link it back directly to the ideas of globalization. So what are the examples that you would end up writing here? You would end up writing US protectionism that has been undertaken under Donald Trump. The examples you can give, tariffs. Right? You can also end up highlighting Chinese weaponization of trade, which is also harming global trade. So in this, you can give the example of Chinese restricting the trade of rare earth elements, or basically rare earth metals. You also talk about weakening of multilateralism, right? Whereby multilateral institutions have been weakened. Weakened by what? Unilateral decisions of country. You can give the example of WHO. You can give the example of UNFCCC in relation to the Paris Agreement. You can give the example of UNESCO. You can give the example of World Trade Organization, which has been harmed by what? The withdrawal of US. Right? It has been harmed by the withdrawal of US itself. Apart from this, how would you also end up highlighting the unilateral policies that various countries have undertaken in relation to problems of globalization? So within this context, you also end up highlighting what the Russians have done. So the Russia-Ukraine conflict, right? Which has also harmed globalization, and the actions that were taken by the European Union also in relation to this. One of the things was sanctions upon Russia, right? By both European Union, the US, and various other countries. And because it has impacted India in terms of our ability, we'll continue to purchase Russian oil, but we're continuously being threatened that sanctions would be put on us, and US has already put sanctions on us in relation to purchasing of Russian oil. So all of these points together, where you end up highlighting sovereign nationalism, you link it back to unilateralism. You give various examples of this: US protectionism, you give the example of tariffs; Chinese weaponization, you give the example of rare earth metals; weakening of multilateral institutions, WHO, UNFCCC in relation to Paris Agreement, World Trade Organization, harmed by US withdrawal. And you also give the example of Russia-Ukraine conflict and the sanctions on Russia by Europe and US on how it is also harming globalization in that particular context. So what you have right now done is highlighted various issues of sovereign nationalism directly being linked with globalization. But you now need also a positive conclusion to this. You have to understand that this is 150 words. You cannot write too much, right? You have to write within the word limit. So make sure that your answer is much more comprehensive rather than elaborative, right? So when you're writing a positive aspect, right? So in terms of your conclusion, you're going to write a positive aspect. In this, what you should do is actually bring in India on how India is supporting globalization. India supports globalization and multilateralism. So we support the reworking of World Trade Organization. We support reform of global institutions or the global economic system. We also support that the US should not put tariffs. We continue to buy Russian oil. So India purchasing Russian oil has also led to, you can say, balancing or stability in the international oil markets. So you end up highlighting that, yes, because of the actions of the Chinese, because of the actions of the Americans, because of the actions of others, the unilateral actions has harmed globalization. But on the other hand, when you're giving a positive aspect, you bring in India on how India has actually led to better support for much more sustainable globalization. Within this, what are the examples you're going to get? So you have this initiative, LIFE, right? Sustainable, which Prime Minister Modi has brought in. You're going to talk about that India supports the functioning of the World Trade Organization again. You're going to add that India has increased its UN funding. Right? India has signed various free trade agreements with other countries. So you can give the example of UK. We're in negotiations with EU. We're in negotiations with US. And we have also signed with the certain other countries around the world. You also end up highlighting that India, within the BRICS, within Shanghai Cooperation Organization, G20, has been a strong supporter of globalization, but more importantly, sustainable globalization. Okay? And you end up concluding your answer on a positive aspect, where you end up highlighting the initiatives and the steps that India has taken to promote globalization. Right? This part is clear to everyone? You look at the next question. Energy security constitutes the dominant kingpin of India's foreign policy and is linked with India's overreaching influence in the Middle Eastern country. How would you integrate energy security with India's foreign policy trajectories in the coming years? 250 words. So within this aspect, you have to bring in energy security. And you have to make the direct linkages also with Indian foreign policy. Indian foreign policy. So you end up highlighting a basic introduction where you signify that yes, India has taken several steps for energy security. About 40% of our energy needs, 40% of our energy needs, both in terms of crude oil plus natural gas, comes from the Middle East. Comes from the Middle East. What is the primary problem that we're facing in the Middle East? Is that the Middle East in itself is volatile. It's a volatile region, plus certain countries are also under sanctions. So here you can give the example of Iran, whereby we used to be one of the largest importer of Iranian gas. Now we're not. So long back, the Americans threatened to put sanctions on us, and we actually did stop buying Iranian gas. The other sanctions was also in relation to Iraq. So when ISIS had taken over Iraq, now the sanctions are being removed from Iraq itself, but there are certain problems within the volatility within the Middle Eastern countries. In this, you also end up highlighting access routes. That it's not just about volatility within the country, but access routes, especially, let's say, the Gulf of Hormuz. For Hormuz, plus piracy attacks that we have seen last year in relation to the Red Sea. That has also harmed energy security for India. So you end up highlighting what the question is trying to ask. You end up highlighting, yes, we import about 40% of our energy needs from the Middle East. There are certain problems that the Middle East has. It's a volatile region. Plus there are sanctions on certain countries. You give the example of Iran, Iraq. There are problems of access also. So you give the example of Gulf of Hormuz plus piracy in the Red Sea, which happened last year itself. Right? Now you need to link it back to Indian foreign policy. Right? So one of the objectives of Indian foreign policy is national security plus economic growth. Energy security, you end up highlighting, is required for both of them. Energy security is required for both of them. So within this context, you end up highlighting what are the steps that India has taken to actually improve its energy security. Okay? So what are the steps that India has taken to improve energy security? So one of the things that India has done, especially in relation to the Gulf countries or the larger Middle East, is we're trying to move up from a transactional relationship to a strategic partnership. Strategic partnership. What it basically means is that earlier we were importers of oil and gas, and the Middle Eastern countries were exporters of oil and gas. It was a transactional relationship. Now what we're moving towards is a much more strategic partnership. What does strategic partnership mean here? Is that joint investment. Okay? So both the Middle Eastern countries and India are looking towards. So ONGC has ONGC Videsh. So you have ONGC Videsh and several now private companies in India that are investing in oil fields within the Middle Eastern countries. So one of the examples that you can give here is the Lower Zakum field. Lower Zakum in the Middle East, where India has invested. You can also give the example of the UAE deal also, whereby a private company in India has signed a particular deal with the United Arab Emirates to develop certain oil fields within that particular country. So this becomes the example that you can also provide here. Apart from this, you also give the example of strategic petroleum reserves. that India has one of the largest strategic petroleum reserves within Asia itself. And you have countries like Saudi Arabia plus UAE that have actually invested within the strategic petroleum reserves within India, and they're actually keeping crude oil in India's SPR also, which India can also use during emergencies. So you highlight that particular point also. Apart from this, we've also moved towards energy diversification. Right? Energy diversification. So we're buying oil from Russia, that all of you are aware of, about 23% as of now from Russia. We're also buying from US. We're also buying from certain African countries. We're also buying from Latin American countries, right? Within this, we're also investing. So Indian oil companies are investing in Algeria. We're investing in Brazil. We're investing in Venezuela, or trying to. Venezuela is right now under sanctions, and various other countries around the world. So both in terms of energy diversification, we're importing from other countries. Plus, we're also looking for joint partnership in other countries. One example you can give is of Algeria. Apart from this, in relation to the energy routes, so you can also end up highlighting that India is also building the Chennai-Vladivostok corridor. India is building the Instek corridor. India is also trying to work on the Tapi pipeline. So these are also various connectivity mechanisms that India is bringing in to ensure that the supply chains of oil and gas in India is continued to maintain, even if there are problems in the Strait of Hormuz or in the Red Sea. And lastly, you also end up highlighting moving away from oil. Right? So you end up highlighting that, yes, as of now, we're dependent on oil, but we have a net zero target in 2070. Right? So in 2070, we have a net zero target. And all of the countries around the world are trying to move towards electric. They're trying to move away from the dependency on oil and gas itself. So that all of these points together, you end up highlighting first in relation to Middle East, 40% roughly our import energy in terms of crude and gas comes from the Middle East. The problems, the volatility, plus in terms of supply chain, security. You link it back to Indian foreign policy. What is our objective? National security and economic growth. So India has taken various steps to ensure this. You end up highlighting 5 different points on how India has ensured energy security in all of these countries. You can also highlight various other points. Like India has also started ethanol blending. So that also becomes a point. So you need to make sure that keeping the word limit in mind, you make your answers comprehensive rather than elaborative. Do not over-explain any point. Just highlight the basics of each of the points. Comprehensive rather than elaborative in that context. And you end up highlighting a basic conclusion in all of this. So what are you going to write in a conclusion? Energy security is a primary factor that guides Indian foreign policy. India continues to buy Russian oil, irrespective of the threat of sanctions, because we prioritize the energy security of our citizens. And in that context, India has taken several steps to maintain energy security in the coming future. Right? So basic generalized conclusion you end up highlighting here, and your answer would be done. All right, coming to the next question. It has asked the reform process in the United Nations remains unresolved because of the delicate imbalance of East and West and the entanglement of the US versus Russia-China alliance. Examine and critically evaluate the East-West policy confrontation in this regard. Now, if you look at this question, it has 2 aspects to this. You have to talk about the United Nations in relation to what is first known as the East versus West. Right? So that becomes the first part. The second part that you would have to talk about is in relation to USA versus China-Russia alliance. Sorry. USA versus China-Russia alliance. Now, if you look at the first part of this, you have to talk about is what are the problems between the East and the West in relation to the United Nations. One of the first difference that you can talk about is reform of the UN peacekeeping forces, right? One of the things that the East, in particularly India and the African countries have asked for is that when the mandate of the UN peacekeeping forces is set, it is decided by the UN Security Council. India has said, and several other countries, that when you're making a mandate where the UN peacekeeping forces should be sent, what they should do there, consult the troop contributing countries or the TCCs. Further, also consult the regional organization, whereby what has happened is that most of the UN missions have actually gone to the African continent. What India has been saying, and several other countries also, including the African Union, is that also consult the African Union. If you look at, if a country has become a failed state and you have sent the UN peacekeeping missions there, it is the neighboring countries that are also the most affected because of the movement of refugees, because of the political instability. The primary solution to this lies with a regional organization that can bring about a political solution. Within this regard, the G7 or the West, they want that the primary understanding of the UN peacekeeping missions should actually remain with the UN Security Council. While India is wanting that you also consult the troop contributing countries and the regional organization. Right? That becomes one aspect. You can also end up highlighting that the East does not support humanitarian intervention. Right? It does not support humanitarian intervention, while the West supports right to protect or humanitarian intervention. Meaning that the Western countries, the US, the European Union, they have been continuously saying that if a country has a humanitarian issue, genocide or whatever it may be, let's have an intervention. Most of the time, the UN Security Council doesn't allow for this. Then they themselves undertake these human or responsibility to protect interventions in those countries. So you've seen this in Yemen, you've seen this in Libya, you've seen this in Iraq, you've seen this in 18 different countries, which the US has bombed in the past 10 years. While the Eastern countries do not support this. They do not like military interventions into different countries. It leads to political instability. So whether you look at Iraq, whether you look at Libya, whether you look at any other country that the US and the Europeans, the French and the others have bombed, all of them have gone through worst phases. They've gone worst with the intervention undertaken by these countries, whether it is Iraq, Syria, Libya, Yemen, or any of these nations. You also end up highlighting that the West generally supports a liberal order. Right? While the East has been that the UN has not been created to promote a liberal order. The UN has been created based on a consensus of the UN Charter. So they are saying a UN Charter consensus-led order. Okay. Meaning all the countries have agreed to the UN Charter. They've not agreed to this liberal order which the Americans and the Europeans have brought out. So there is a difference. The liberal order is much more vague. It is completely being decided by the Western nations. What is part of this, what is not a part of this. While the UN Charter is written down, all the countries have agreed that are part of the UN that we're going to follow the UN Charter. So it's much limited in scope. You can discuss this, you can agree upon it, and you can therefore either take actions to what the UN Charter has said by a consensus mechanism within the UN General Assembly. Another problem that has occurred is between universalism versus relativism. And this biggest example is seen in relation to the UN Declaration of Human rights. Like the UN Declaration of Human Rights also says the ability to have political participation. Now you look at certain countries of the East, especially theocrats like Saudi Arabia or dictatorships like North Korea, they don't agree with this. And they're parts of the UN Declaration of Human Rights that a lot of the Eastern countries have ended up saying that it really does reflect European values. It reflects the Western-led global liberal order. And they consider, or the Western countries consider, that there are certain principles which are universal, like the UN Declaration of Human Rights, while the Eastern countries consider that they're relative. Your values or your rights may not be the same that we value. Our rights and our culture and our aspects might be different from yours. So here, the biggest example you can give is of the UN Declaration of Human Rights. Another aspect between the East and the West, you can also highlight the US versus China and Russia and how it is also impacting the United Nations. All right. One of the first problems that you end up seeing is the same you see in East versus West, is of UN funding. Because of US withdrawal, the point becomes a little different here. Because of US withdrawal, it is China that is fulfilling the funding responsibilities where the US is not. So this we see actually with the World Health Organization. When the US withdrew from the World Health Organization, this is prior to COVID, it is China that ended up funding. And then a lot of the management in the World Health Organization were backed by the Chinese. Then the COVID pandemic hit. We understand that there were certain parts from China, from Wuhan, that it had originated. But what had happened is that the World Health Organization therefore ended up protecting China in relation to the truth that might have been of the COVID pandemic. And this becomes the primary problem when the US withdraws from funding of the UN bodies, and it is countries like China that end up, well, filling that vacuum. Another problem that is there between the US versus China, Russia-China alliance is over the use of veto in the UN Security Council, whereby Russia and China end up vetoing whatever, let's say, the US, UK, and France, or the Western countries would end up supporting, and also the other way round. So when the US invaded Iraq, Russia tried to basically say that what the US has done is wrong, supported by the Chinese. The US and the other countries, US and UK especially, ended up vetoing it. When Russia ended up invading Ukraine, you had the Americans trying to bring in a resolution to condemn it, completely being vetoed by the Russians. So the use of the veto by these powers have basically made UN Security Council unresponsive or unworkable. Another problem that happens between the US and the Russia-China alliance is over the debate on obstructionism versus unilateralism. The Americans end up saying that the Russia and China are obstructing the working of the UN Security Council by obviously vetoing things on, let's say, Taiwan, on Ukraine, on things that might have been favorable to the Americans or the West. While the Russia and the Chinese have accused the Americans of being undertaking unilateral actions, more particularly in relation to the Iraq War, or the second Iraq War, or the bombing in Libya, or the bombing in Yemen. The recent example you can also give is the bombing of Iran, whereby both the Russia and the Chinese wanted to condemn the bombing by Israel and by the Americans of Iran, but again, completely being vetoed by the Western powers. The other problem that also happens is that the US criticizes Russia and China for human rights violation. Human rights violation. But it is Russia and China that end up saying that the US uses it selectively. The US ends up looking at the human rights violation undertaken by Russia, China, and other countries, but they refuse to acknowledge the human rights violation that they have done, whether in Afghanistan, Iraq, Yemen, or any other country. And the example that you can give here is of the UN Human Rights Council. Initially, when the UN Human Rights Council was controlled by the Americans, they would criticize the Chinese and Russians. Now, because of the US withdrawal, it is now being controlled by the Russians, the Chinese, and their allies, which now they end up condemning, or they end up refusing to acknowledge human rights violation of their allies. So these are the primary problems that you end up highlighting as East versus West and the USA versus China-Russia alliance. You end up highlighting 5-6 points here, 5-6 points here, because you have to also keep the answer within the word limit. Then you get to the conclusion of this. The conclusion, obviously, you have to end on a positive or optimistic note. And when you're ending on a positive and optimistic notes, you bring in India, right? So you end up saying that India supports various policies of the East within the UN Security Council. You can give the example where we ended up supporting that the Chagos Island should be given back to Mauritius by the UK. You can also highlight the troop contributing countries issue, and we support the role of regional organizations, especially African Union, in terms of UN. You can also bring in the idea of G4, where India supports the expansion of the UN Security Council. We also support African Union getting a seat within the UN Security Council also, or an African country getting a seat in the UN Security Council also. India has increased its funding of UN bodies. And you end up highlighting with certain few points where India has worked for betterment of the UN. And within this, you end up also highlighting that we're the largest cumulative provider of soldiers to the UN peacekeeping forces. You end up highlighting basic points where India has actually improved the UN. And you end up at the end saying that India is a bridge. India is a bridge between the East and West. East and West. Why? Because the question ends with the East-West problem. So you end up saying that India is really a bridge between the East and the West itself. All right. So if you look at all of the questions, you end up highlighting the primary problems that have come. You end up highlighting what are the steps that India has undertaken, and you end your answers never in a negative note, never in a pessimistic note, but always in a positive and optimistic note. Over time, you have to understand that you can write multiple points in any of the answers. Like if you take this question, where you're talking about, let's say, connectivity initiatives, you can also bring in I2U2. You can also bring in IMEC corridor, where India is trying to improve regional connectivity for energy security. You can also bring in the Asian premium and all of these aspects. Content is not really always an issue within a UPSC answer. It is the ability to concise your content to 150 words and 250 words so that you meet the demand of the question. That is why answer writing is very essential when you're preparing for UPSC. I hope you have understood on how the questions were framed in international relations and how you should have approached the answers. Take care, everyone.